Hi there, how are you doing? In today's class, we are basically going to be looking at what is known as the doctrine of stare decisis, also known as the doctrine of precedent. So, in this video, we're going to define what this doctrine is about. We'll also be looking at the types of precedents, and then we're also going to be looking at exceptions or circumstances where actually a court may choose not to follow the doctrine of stare decisis. Once again, ladies and gentlemen, my name is Mutiawa Conrad. I'm a lawyer and a private law tutor, and I encourage you to ensure that you subscribe to my channel, to also like and share, and also ensure that you turn on the notification so that every time videos are released, you always get to be in the know and you're able to benefit from these videos. And also for students that are interested in private law tutorial sessions, you may be having challenges at university or at whatever entity you are in, please contact us. We can always give you private tutorial lessons. These lessons have been proven to work, and students who actually get some sort of mentorship have been proven to outperform their fellows who have or do not have any such type of mentorship. So, ladies and gentlemen, let's start right away by looking at the definition. So, when we talk of stare decisis, what do we mean, or also known as the doctrine of precedent? Basically, this is a principle of English law where precedents are deemed authoritative and binding and must be followed by other courts of law, especially inferior or lower courts. Now, precedent means a judgment of a court of law quoted as authoritative for deciding a similar fact, or can also be defined as a judgment or decision cited so as to justify a decision in a later similar case. Now, it's important to note that a case is only an authority for what it actually decides. The purpose of precedent, or the purpose of the doctrine of stare decisis, was actually stated by Sir George Jessel, Master of Rolls, in the case of Re Hallett, a case of 1880, volume 13, Chancery, page 712, open quotations, that the only use of authorities or decided cases is the establishment of some principle which the judge can follow in deciding the case before him. So, ladies and gentlemen, when we are talking of the doctrine of stare decisis, here what we mean is that there are certain cases that will be adjudicated by courts. Okay, for example, any case that you may find in your country, such a case forms a precedent, and when courts are giving judgments, they will ensure that they follow decisions of previous judges or decisions of previous courts. Why is this important? This is important because it helps to create continuity in judgments. It helps to avoid contradictions in judgments. And basically, that's how the legal system operates. Cases are decided based on previous cases. That is, if those cases, the facts in those previous cases or in that previous case are actually similar to the facts before court. Okay, this is very important to note. And it's important to note, as we are going to see, that they are what we call types of precedents. Okay, and actually, that's what we should basically be looking at now. Now, we proceed to look at the types of precedents. Types of precedents include one, original precedents. Okay, now, an original precedent is one which creates and applies a new rule or legal principle. Okay, for example, you can look at the case of Susan Chibula and others versus the Attorney General. You can find it online. Now, in this case, the Supreme Court declared that the death penalty is not mandatory and can only be imposed at the discretion of the trial judge. That is an example of an original precedent. Okay. The other precedent that is important to note is what we call declaratory precedents. This is one which is merely the application of an already existing rule of law. So here, under declaratory precedent, court is simply trying to establish an already existent rule of law. Next is what is known as authoritative precedent. This is one which is binding and must be followed by the lower courts of law. An authoritative precedent is binding on all lower courts, and if cited in court by a lawyer, a judge has an obligation to ensure that they actually follow that precedent. Of course, we are going to briefly be looking at the exceptions. Lastly, is what we call a persuasive precedent. Now, this is one which need not be followed, but is worth consideration. For example, decisions in other common law jurisdictions, i.e. the Supreme Court of Kenya, USA, Tanzania, the House of Lords in England, etc. That is for the Ugandan case. And please let me draw more light here. For persuasive precedents, those are precedents that will be cited in court, but they are from other foreign jurisdictions than those for which you're actually litigating. For example, if you are in Uganda, decisions that you'll cite from other countries besides Uganda are only persuasive to the judge, meaning that the judge may choose to follow them or not, but they are persuasive. I hope you draw the distinction. If you are in, let's say, the UK, and you cite Ugandan cases, again, they are only persuasive. They are not authoritative. Court will look at them, the judge will look at them, consider the principles, and if the principles are squarely applicable to the British or Kenyan scenario, then he will apply such cases. They are persuasive. Whereas authoritative precedents, these ones, court is mandated to follow them. They are binding, especially on lower courts. For example, if you are in the High Court of Uganda and you cite a Supreme Court decision, the High Court has an obligation to follow that decision, okay? It has that obligation. Of course, it's also important to highlight at this juncture that there are exceptions. There are scenarios or situations where even when you actually cite what we call an authoritative precedent, meaning a case of that same country, the judge can actually choose to depart from it. And this is really very important to note. Some of the techniques that court can actually use to depart from it include, one, the skill of distinguishing cases. Court can actually depart from an authoritative precedent by distinguishing it. What do we mean here? What we mean is you may cite a case which is of the Supreme Court in a high court. Ordinarily, that is an authoritative precedent which the judge should actually follow, which is binding on him or her. But in case the facts you're citing are distinguishable from the case that is currently being handled by the judge, then the judge will depart from such an authoritative precedent, even though ordinarily it would have been binding on him or her. The other second exception is what we call decisions of or authoritative precedents that are decided per incuriam. Now, if you're, for example, before the High Court and you cite a Supreme Court decision, but that Supreme Court decision was decided per incuriam, meaning that when court was arriving at a decision in that case, it actually considered the wrong law or applied the wrong principles of law. Such a judge of the High Court, even though it is actually an authoritative precedent, which ordinarily should be binding, such a judge can choose to actually depart and not follow such a precedent. That is what we call, that is for purposes of judgments that are, although authoritative, but were decided per incuriam. So basically, those are the two exceptions. There are also others. I encourage you to go and do further research and find out those other exceptions or scenarios where actually a court will divert from an authoritative precedent of a higher court. But as a general rule, all precedents, especially of that country, have to be followed by lower courts. It is also important to note at this juncture, however, that the Supreme Court, which is the highest court of the land, for it, its previous decisions are actually not necessarily binding on it. meaning that the Supreme Court at any material time can actually decide to divert away from its own previous decision. And actually that is provided for under the 1995 Constitution of the Republic of Uganda. So important to note that the Supreme Court is not bound by its previous decisions. It will consider them, it will look at them, but should it feel that actually its previous decisions were arrived at erroneously, then it can actually depart from them. This is very important because the law keeps on growing every time. You may find that the circumstances at the time such a Supreme Court passed a judgment, maybe 20, 30 years ago, the culture has changed. The values or aspirations have changed. And as such, the Supreme Court can always divert from its previous decisions. So ladies and gentlemen, basically, that is all on the doctrine of stare decisis, also known as the doctrine of precedent. Once again, my name is Mutiaba Conrad. Please ensure that you subscribe, like and share my channel, and also turn on the notification so that you're able to always get alerts whenever these videos are released. Again, students interested in private tutorial sessions, please reach out to us. We'll get you an expert to tutor you at your office, at school, or in your holidays. And our numbers are basically down in the description box. Thank you very much. We meet again in another class. Bye-bye.